Hi everybody, Armine Bazikian from Bazikian Law Group. Today I wanted to discuss a special topic that a lot of people always want to discuss, and that is what happens after I've bought my first home. What do I need to do next? What's the next step to financially protect myself? And this is a really good question, and a lot of times people will not take that next step to make sure that their assets are protected. So it all depends on how you took title to that property, meaning what type of owner are you of that asset. So we actually did a 3-part video series over the last several months that addressed the various title ownership methods that you can utilize when you're purchasing a property. So feel free to watch those to kind of gain more knowledge on those. But for today's example, I'm going to be using a single person as an example. So it'll only be one individual that owns the property. So let's say that Bob goes out and buys his first property for $600,000. He's a single guy. He's not married, has no children. Both of his parents are living. So he buys the property and he takes title as, Bob Smith, a single man. And then a few months later, he unexpectedly passes away. So the question would be, what happens to that property? Who gets it? What do they need to do to actually transfer it into their name? So unfortunately, Bob didn't do any planning. He didn't do any estate planning. So that property needs to go through the probate court system in order to get to his beneficiaries. So his parents would have to open up a probate case and probate the property. Now, this would be, as you've probably heard me say previously, a very expensive process and a very lengthy process. But let's run through the examples. So he purchased the house for $600,000. Let's assume that the value is still $600,000, and he has a $500,000 mortgage, meaning he has only $100,000 in equity that at the end of the day is going to go to his beneficiaries. So his parents open up a probate case. The attorney fees alone for that probate case will be based on the value of the property, the $600,000. They won't take into consideration that he has a mortgage. So the probate attorney fees, which are set by law, will be somewhere around $17,000. There will be another $200 to $300 to about $2,000, depending on the particular situation, in costs. So filing fees, recording fees, publication fees, possible bond that might be required. So these are all expenses. So Bob's parents are looking at about $17,000 to $20,000 that they need to spend to get that $100,000 in equity that Bob put into the property or has in the property. So it's a significant portion. It's about 1/5 of his equity, which is an alarmingly high amount. But that's what happens when you don't do planning. You end up spending money on things that you didn't have to spend it on, that his parents could have avoided. So once everything is said and done, and the probate court orders the property to be distributed to Bob's parents, Bob's parents will pay the attorney fees and all the costs that are associated with it. At the end of the day, they'll get about maybe $70,000 to $80,000 of the equity that was in the property. So it's a very costly process, as I've mentioned before. And Bob could have simply avoided this process by taking that next step after becoming a property owner to better protect his investment. So had Bob created a comprehensive estate plan with a living trust that would have cost him a couple $1,000s, he could have avoided his parents foregoing or losing out on a $20,000 chunk at the end of the day. So when you're comparing an estate plan and a probate process, a couple of $1,000s versus about $20,000, it's a significant difference. And of course, it's all pre-planned ahead of time, so it would have provided him with an ease of mind, and it would have covered him had he just been incapacitated and not actually passed away. So of course, for the parents, it would have made a huge difference because they would not have to wait about 1.5 years to get the property sold and get their investment amount for Bob. They would not have made Bob's assets public information. It would have been a family affair behind closed doors. So depending on how you hold title to your property, your rights are affected based on that. So I would encourage you to check with the grant deed or the deed on your property to make sure that you hold title to the property the way that you want to hold title to the property, and then give us a call if you don't know. We'd be happy to check for you and let you know exactly how you hold title to your property. And if you'd like to come in for a free consultation, we can give you a rundown of exactly how it impacts you if something were to happen to you unexpectedly, how that property would be transferred to your loved ones, whether it would be automatic by operation of law or probated or whatnot. And we can give you a play-by-play, and we can also provide you with some information about what it would take to create an estate plan for you and what the cost would be. So feel free to contact our office for a free consultation. I'd be happy to sit down and talk to you about it in detail. Bye.